Well, thank you also, Elder Patterson, for those words and so on. Well, it's a great pleasure to see so many people out today. Together with some of my colleagues, we've been planning this for a little while now, so it's really rewarding to see so many people out. And as you know, the impetus for this symposium is the reality of what the Supreme Court has called, rightly called, the crisis of overrepresentation of Aboriginal people in Canada's prisons and jails. And we wanted to bring lawyers, judges, academics, community members, law students together to take stock of where we are in terms of addressing that crisis, or where we aren't in many ways in terms of having made progress since the really groundbreaking Aboriginal Justice Inquiry report in 1991. And then, just a few years, well, almost a decade later, my colleague, Professor Wendy Whitecloud, doing the AJI Implementation Commission report. And now we're, over 10 years since that as well. And there's been some limited progress in some areas that were identified in those reports. But the crisis of overrepresentation of Aboriginal peoples has got worse, not better, in the period since the AJI, and really increasingly every year. And fully 1/4 of all prisoners in Canada are Aboriginal, where, of course, Aboriginal people make up less than 4% of the overall population. And in Manitoba, we're talking 70%, upwards of 70%. And one policy change, which is the sort of centerpiece of what we're looking at today, that's been the source of much debate, relates to the sentencing of Aboriginal people convicted of crimes. And it's that provision and the first case interpreting it, Gladue, that we take the name of for this symposium. And as many of you and the people in this room know, and there's a lot of experience, I look around this room, the Canadian government amended the Criminal Code in 1996 to include this provision as part of broad-based sentencing reforms to create alternatives to incarceration and to reduce reliance on imprisonment and bring a host of other changes to sentencing. But there is this provision: all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. And the Supreme Court interpreted that, of course, in the Gladue case in 1999. They noted that Parliament's intent was to respond to this crisis as part of these broader reforms. And the court referred to discrimination experienced by Aboriginal people in the justice system, as well as other systemic factors that contribute to this overrepresentation. So courts were called in the Gladue case to undertake the process of sentencing Aboriginal people differently in order to meet the primary goal of sentencing, finding a truly fit and appropriate sentence. The court spoke quite openly of systemic racism and the way it translates into disadvantage at various stages of the criminal justice system. Sentencing courts were called on to consider systemic and background factors that brought the person before the court, as well as sentencing options that could be implemented in a particular case with a focus on community and restorative programs that might actually address some of those factors. And the hopes that many of us had, why is this happening? The hopes that many of us had for Section 718(2)E of the Code and for Gladue have largely not been realized. Although there are some promising developments, and I don't want to suggest that there hasn't been some progress, and we'll hear about some of those various initiatives more on the second panel today. So why has Gladue not been more effective? This is the key question that we will focus on in this first panel. And there are a number of different explanations that might be offered, and they will probably very much depend on your own view of the reasons for overrepresentation in the first place, your view of the criminal justice system and its role, and your view of, social change. I will simply offer a few of my own thoughts, which stem from what I see as some pervasive Gladue myths. And as I thought about this presentation, I listed 8 or 10. And I could have gone on off the top of my head of things that I consider myths, both about Gladue and about Aboriginal people in the justice system and about a whole host of things. But I'm only going to do 3 today. And I'll just sketch them out very briefly for you in the interest of time. Myth number one, prisons work. And, prisons work for Aboriginal people. This is a very pervasive myth. And, in fact, there's a huge body of research, built up over decades which shows very clearly that prison does not deliver on many of its promises, or at least not to the degree that it is touted as a response. Public safety, rehabilitation, deterrence, to name just a few. And the 1996 amendments, of which I just spoke, and of which the Gladue provision is just one, were built in part on the foundation of that research and understanding by policymakers that this approach was not working. The court in Gladue stated, and I'm quoting from the decision, as has been emphasized repeatedly in studies and commission reports, Aboriginal offenders are, as a result of these unique systemic and background factors, more adversely affected by incarceration and less likely to be rehabilitated thereby, because the internment milieu is often culturally inappropriate and regrettably discrimination towards them is often rampant in penal institutions. Recidivism rates for those who've done jail time are higher for Aboriginal people than non-Aboriginal people. And, I could say much more about this. People who know me know that I am quite a strong critic of our use of imprisonment generally. But until we just debunk this myth, we won't get very far. And I should say that, and many of you know, that Parliament has been quite busy passing laws over the last while that are packing our jails even further and requiring us to build more prisons at great fiscal and human cost. Our governments are very vocal, including our government here in Manitoba, in calling for this increased use of imprisonment. And it's my strongly held view that it flies in the face of reason and the facts, and that we need much more concerted effort at looking at alternatives to incarceration. And we have some examples of lots of programs that do work, and we need more investment in developing programs that do work. Myth number two, Gladue only works or applies to a limited number of Aboriginal people. And I think this myth has a number of components, all of which we see in the case law and in the attitudes of many involved in the justice system. Gladue doesn't work in an urban environment. Gladue doesn't work for serious offenses. Some of these other myths will be addressed by my colleagues on the panel. Gladue doesn't really work, ironically, in jurisdictions where the majority of people coming before the courts are Aboriginal. We have had decisions from courts that exemplify each of these myths. And with respect to the last one, arguably, Gladue has had the least impact in jurisdictions such as Saskatchewan and Manitoba, and maybe I'm being provocative here, where overrepresentation is worst, and where uptake by the criminal justice system has been cautious and slow, I would suggest, as compared, for example, to some of the developments in other jurisdictions. I'm just sketching these out so my panelists can take up some of them later. Myth number three is Aboriginal overrepresentation is an intractable problem that's too complex to be dealt with through sentencing. And there are a number of components to this myth. One is that sentencing is too late in the game to make change. Even if one believes that courts and policymakers in various believes that, and as I said, courts and policymakers in various jurisdictions have in fact applied Gladue principles to other stages in the criminal justice system, notably bail, where Aboriginal people are more likely to be denied bail, but also to corrections, review board hearings and mental health, a number of other areas. So it's actually Gladue and the principles there, while it's in the sentencing provisions of the criminal code, has relevance at other stages of the justice system. So that's just one piece of it. But a more fundamental component I see of this myth is the idea that Aboriginal overrepresentation is not a criminal justice problem at all. It's a complex social problem, and that pouring money into various aspects of the criminal justice system won't see results. Of course, on one level, it's true that colonization, residential schools, and a host of other policies have left Aboriginal people and communities traumatized, poor, and unable to deal effectively often with issues in their communities. There are no easy fixes, but the criminal justice system is clearly implicated in perpetuating these problems. I just recently had someone send me a memo written by Rupert Ross, and many people probably know Rupert, a Crown attorney for many, many years in Northern Ontario. A memo he wrote kind of as a call to action, both to his others in working in the Crown Attorney's Office, but also to the Department of Justice federally, called Traumatization in Remote First Nations, an Expression of Concern, in which he really expressed his belief after, I think it was 21 years at that point, that, that more harm seemed to be being done more than good through his efforts in trying to address, real problems, real trauma that's happened in the communities he was dealing with. So on one level, it's true. Furthermore, the idea that there are so as I'm saying, there's no easy fixes in the criminal justice system, but it is. I do think the criminal justice system is implicated. Furthermore, though, the idea that there are not resources to spend, or that resources directed particularly at community-based alternatives to our incarceration would not be well spent, I think again flies in the face of facts and reason. Our governments are spending billions of dollars on imprisonment, but comparatively very small amounts on community alternatives and capacity building in Aboriginal communities to address these challenging issues. We know that legal aid is already stretched, very thin, to trying to meet the basic demands for representation in criminal law and some civil matters. Lawyers who try to argue for more culturally appropriate community-based sentences for their clients are often faced with a lack of available options, resources in the community to which the person could actually be directed. The Hollow Water program here in Manitoba is a model that has been developed by one Aboriginal community, and that has shown positive results. The Aboriginal Healing Foundation has published a report on promising healing programs, but there is such an incredible demand for such programs, and the demand would be even higher, I think, if the justice system, I think, was more responsive to those interests and not so oriented towards punishment and imprisonment. So on one level, resources are necessary to make Gladue a reality, but in my view, it's also a shift in thinking that is necessary. And so I just wanted to open up with some of those opening thoughts around the shift in thinking that I think needs to happen. Obviously, it's not that there's nobody thinking about these issues, but I think we could do better. And so that's part of why we've brought some other people together to talk about some of these things. Thank you.